The one signature missing from your paperwork that cost your kids $60,000? Somewhere in your house right now, there's a form with a blank space on it. Not a scary form, not one anyone warned you about, just a line that says beneficiary that nobody ever got around to filling in. And that one blank line is the difference between your family getting your money in 10 days or fighting for it in court for a year and a half. This video is about exactly what happens to your money, your house, and your accounts the second you die, and the handful of small things you can do this week to make sure none of it turns into a mess for the people you love. 4 things change the instant you die. I'm going to go through each one, tell you exactly what breaks if you've never touched it, and tell you the specific fix. None of this requires being rich. If you have a bank account, a house, or a retirement account, this is about you. Start with the bank account because it's the easiest one to fix and the one almost nobody has actually looked at. The moment your bank finds out you've died, usually within a few days, it locks your individual account, not the joint one. Your account, the one with only your name on it. Nobody can touch it. Not your husband, not your wife, not your kids. It becomes part of your estate, and the only door back into it runs through probate court. Here's where the real money gets lost. A bank account sits in one of 3 setups. Sole ownership, meaning your name only, no one else listed anywhere. Joint ownership with survivorship rights, meaning a spouse or partner is also listed as an owner, and the money passes to them automatically the second you're gone, no court involved. And the third option, the one nearly nobody sets up, called payable on death. You name a person directly with the bank. When you die, they show up with a death certificate and an ID, and the bank releases the money to them, usually within 1 to 2 weeks. No lawyer, no judge, no waiting. If your account has no joint owner and no beneficiary listed, it goes into probate, and probate is not fast, and it is not free. Attorney fees, filing fees, executor commissions, and appraisals typically eat somewhere between 3 and 8% of the estate before your family sees a dollar. A paid-off house, a retirement account built over 30 years, and normal savings can easily add up to $1 million estate without anyone thinking of themselves as wealthy. At that size, probate can quietly take somewhere around $40,000 to $80,000, and the process itself often runs close to a year, sometimes longer. That's where a number like $60,000 comes from. It's not a scare number, it's a documented, ordinary outcome. So here's the fix, and it costs nothing and takes about 10 minutes. Call every bank and credit union where you hold money in your name only. Ask them directly, does this account have a payable on death beneficiary listed? And if not, can we add one today? Do this for every account by name, checking, savings, and any certificate of deposit, because adding a beneficiary to one account does not automatically cover the others, even at the same bank. If you hold stocks or funds in a brokerage account, this is a different form entirely, called transfer on death, filed with the brokerage, not the bank. Same idea, same result, separate paperwork. Now, a warning about a fix: a lot of people try on their own because it often backfires badly. Adding your adult child to your bank account as a joint owner, not a beneficiary, but an actual co-owner, feels like the easy solution when you need help paying bills. But it makes that money legally half theirs right now, while you're alive. If your child gets sued, that account can be reached by their creditor. If they go through a divorce, that account can end up in the settlement. None of that requires anything to go wrong in your life, only theirs. If you need someone able to manage your account while you're alive, a power of attorney does that job without putting your money at risk. Also worth checking, even if you set it up years ago, an old beneficiary listing doesn't update itself. An ex-spouse, a parent who's since passed, a sibling you've drifted from, whoever is named on that form is who gets paid, regardless of what your current will says. If you haven't looked at that name in 10 years, this week is a good time to look. And if you keep documents in a safe deposit box, know that banks typically seal those boxes the moment they learn of a death. even if someone is holding the physical key. Getting it reopened often requires the same court process as an unfrozen account, which creates a frustrating loop if your will is sitting inside. Where the bank allows it, adding a trusted person as a joint renter on the box solves this ahead of time. Next, your house and any investments outside a retirement account. There's a rule in the tax code that works entirely in your family's favor called step up in basis. Say you bought your house decades ago for $80,000 and today it's worth $500,000. Sell it while you're alive and you owe capital gains tax on most of that growth. But if it passes to your kids when you die, the IRS resets the cost basis to what the house is worth on the day you died. Your kids could sell it the next day and owe capital gains tax on none of the growth that happened during your lifetime. But a house can end up in probate the same way a bank account can if there's no beneficiary and no joint owner attached to it. And since a house is often the largest asset in an estate, it's usually the biggest driver of those probate costs. The fix here is a transfer on death deed, sometimes called a beneficiary deed, filed with your county. You name who inherits the house directly on the deed, and it passes to them automatically, no court involved. Most states now allow this. If yours doesn't, a living trust accomplishes the same thing, though it takes more setup. This step-up rule applies to stocks and funds too, with one major exception. It does not apply to IRAs or 401ks. Which brings us to inherited retirement accounts, and this is the part people get wrong most often right now. Under current law, most people who inherit an IRA from someone who isn't their spouse have to empty the account within 10 years. Most people have heard that much. What fewer people know is whether they're also required to take money out every single year during that window, not just by the end of it. That depends on whether the original owner had already started taking their own required withdrawals before they died. If they had, the beneficiary generally has to take a withdrawal every year too, and missing one can trigger a real penalty on the amount that should have come out. The IRS eased enforcement on this for a few years while the rule was being clarified, but that grace period is behind us now. If you've inherited an IRA from a parent or anyone other than a spouse recently, call the institution and ask directly whether the original owner had started required withdrawals and whether you owe one this year. Get the answer in writing if you can. Last piece, whether your estate itself owes tax, separate from anything your heirs owe personally. Here's some genuinely good news. For deaths in 2026, the federal estate tax only applies to estates worth more than $15 million, and that threshold is now permanent rather than set to shrink back down. For almost everyone watching this, the federal government simply isn't going to tax your estate. But that's not the only threshold that exists. A number of states run their own estate or inheritance tax completely separate from the federal one, and some kick in far lower than $15 million. Oregon, for example, applies its estate tax starting at $1 million. If your house, retirement accounts, and life insurance together push past your state's number, your estate can owe state tax even though it owes the federal government nothing. It's worth 5 minutes to search your own state's name along with estate tax and check the actual threshold, not just whether the tax exists. Put together, these aren't 4 separate problems, they're one situation. Your bank account either reaches your family in 2 weeks or sits frozen for the better part of a year, while money quietly disappears into legal costs. Depending on one beneficiary field, your house and investments either pass on tax-free or they don't, depending on how they're titled. Your inherited IRA either gets handled correctly or it accumulates a penalty because nobody asked the right question at the right time, and your estate either owes nothing or owes a state tax you didn't know existed. Here's what I do in order. This week, call every bank and credit union where you hold an account and ask about adding a payable on death beneficiary. It's free and it takes minutes. Then check whether your house has a beneficiary listed on the deed and look into a transfer on death deed if your state offers one. If you've inherited an IRA from anyone other than a spouse recently, call and ask about the annual withdrawal requirement before a penalty fines you first. And spend 5 minutes looking up your own state's estate tax threshold, not just the federal one. None of this needs a lawyer or a complicated plan. It needs one phone call and one honest question asked this week, while you're still the one who gets to ask it. This video is for general education only and isn't legal, tax, or financial advice. Rules vary by state and by institution, so confirm your own numbers before acting. If this was useful, send it to someone you know who has a house, an IRA, or a bank account with only their name on it.